under the supervision of a qualified business rescue practitioner, and therefore, in so doing, to return the company to a solvent going concern. What subsequently transpired is that after a number of business rescues where it was where they couldn't return the company to solvent going concerns, it became acceptable for business rescue practitioner to return a company or to give creditors a better return than they would get in a liquidation scenario. So yes, the purpose of business rescue is basically to give that company breathing space for a short amount of time. The Companies Act envisaged a 3-month period, but subsequently many business rescues have carried on as long as a year or 2 years or even more. So to return a company to a solvent going concern and to properly do a business rescue often takes a bit longer than the prescribed 3 months. Peter,
that's where you get the extensions and stuff. So let's just go to the definition of business rescue. We'll start with affected person, because this is relevant when it comes to the voting on the plans and the rights that are afforded to the affected persons. Essentially, they have legal standing when it comes to the provisions in the Act. So we have a shareholder, registered trade union, and employees. The business rescue, you'll see, relates to the temporary supervision of the company. It's temporary. Business rescue practitioner comes in, and importantly, it's a temporary moratorium that kicks in. So in the current state of affairs, we, as COBRA, are going to try and avoid business rescue by mediating on a pro bono basis the arrangements between the debtor and creditor. Okay? If, however, the creditor, and that's to avoid business rescue, to keep the company out of business rescue, if, however, the creditor starts becoming heavy-handed, which really ought not be the case under the current climate, but if the creditor becomes heavy-handed, then to level the bargaining power between the debtor and creditor, one goes into business rescue, so the moratorium kicks in. So you don't have this gun to your head. Though creditors do try, often they try and convert to business rescue into a liquidation. Lisa, can you just take us through financially distressed? What's meant by that? I've got it on the screen, but yeah. We can't hear you, Liz.
Essentially, the test for when you should place a company into business rescue is whether or not that company is financially distressed. Financial distress basically deals with either factual insolvency, which is essentially when a company's liabilities exceed their assets, or when a company is reasonably unlikely to be able to pay its debts within the immediately ensuing next 6 months.
Yeah, and that's known as commercial insolvency. It's important for the audience to realize that there are two types of insolvency. The one is where your liabilities exceed your assets, and in that case, obviously, it's far more difficult to rescue a business as opposed to a commercially insolvent company, which merely means that the company is unable to pay its debts as and when they fall due, but the net asset value may very well exceed the company's liabilities. And that's obviously a perfect case for business rescue. If, however, the company is factually insolvent, you hear about rescue in the term business rescue, but another basis to place a company into business rescue is if you're going to get a better return than a liquidation. So in other words, a liquidation often involves forced sales, and it involves blanket percentage fees for the liquidator. So it's 10, 6, or 3% that they just get. Whereas a business rescue is paid by the hour. So a business rescue is often, just when it comes to a liquidation, an ordinary liquidation of the assets, preferable to an actual legal liquidation in terms of the Companies Act.
So essentially, you can use business rescue to deal with a cash flow crunch, which obviously a lot of businesses are dealing with at the moment.
Yeah, no, that's precisely it, and a lot of the businesses still remain factually solvent. So just on how does one commence legal proceedings? I think if you could take us through that, Peter, section 129, which is on the screen. But thank you.
Morning, everybody. Thank you. Two ways to go into rescue. It's either a resolution of the directors. It's the most simple way to do it. Or any affected person can apply to the court to place the business into rescue. Just a few highlights there before I get to the resolution side. A trade union can approach the court. A shareholder can approach the court, or a creditor. So basically anybody, and remember, companies owe their shareholders the money that they put in the first place, even though they stand at the very back of the queue. They too have the right to approach court to place it into rescue. Interesting point there is, I was having a discussion yesterday. We've just had an announcement in the last 10 days that Edcon Group is not going to be able to pay their creditors for the next 3 months, and that they're using a concession allowed by the CRPC to avoid Section 22 of the Companies Act. That's the section that deals with reckless trading. So it's been withdrawn, but only for companies that are failing because of the virus. Company that was failing prior to can't claim the concession. And Edcon are doing that, I've no doubt, during this disaster period to try and sort out their financial affairs, because obviously all their stores are closed. And the advice to one of the creditors there was to immediately apply to court as soon as the court's open to have it placed in rescue, so that the company isn't placed into liquidation. As far as the resolution, it really is a simple process. The directors obviously discuss it. They have to take a vote on it. It has to be 50% plus voting for the rescue. If it goes through at a board level and it is agreed, bear in mind the shareholders, if it's an independent board of directors from the shareholders, have no say in this. The directors are taking this decision. The directors then record that in the resolution. They appoint one of their members to sign all documentation at Sub-C, who then has to do a sworn affidavit in front of a notary, which is stating broadly why the company's in rescue, and that's very broad, and merely stating the fact that it is in rescue because of the financial distress that we talked about earlier, that Lisa Marie talked about, and then file that at Companies House with a Companies House form. As soon as it's filed being sent by email to the Business Rescue Unit at Sub-C, the company's then in rescue. There is an interesting point here that, as Ian and I have discovered both as practitioners, that a lot of people won't discuss anything with you about the affairs of the company until you've got the stamped CRPC form, specifically the banks. So there's a bit of an anomaly there, but it is once the document is filed that the company's immediately in rescue. A lot more difficult to come out of rescue than it is to go in. Maurice, I think that's it. There's something in the back of my mind that I've forgotten to mention, one thing, but I can't remember what it is for the moment.
No, that's pretty it. I just want to go back to, deal with the moratorium now, because the moratorium is probably the most important aspect and most useful aspect of business rescue. Now, this is where it's really important to appoint an experienced business rescue practitioner, because in terms of the Companies Act, it's up to the business rescue practitioner to send a notice to suspend contracts, and we'll get to that. If that notice does not go out to the creditors to suspend the contracts post business rescue, then one finds oneself in a situation where the counterparty to the contract, i.e. the creditor, can in fact place you in breach and terminate the contract. Now, if it's, let's say, a landlord-tenant scenario, such in a case where Judge Barachowitz handed down judgment, and the cancellation is effected prior to the suspension by the business rescue practitioner, then an eviction is appropriate, despite the moratorium being in place. So that's key. There's several takeaways from today, and that's a very, very important one. If you're not going to go elect to go within the COBRA environment, let's say you know a business rescue practitioner, make a note to tell the business rescue practitioner about all contracts. So have those ready, and have the business rescue practitioner with contact details and whatever, and have the business rescue practitioner send those notices out. It's key. I think there's a note, and I think, yeah, it's quite important. I should have mentioned these discussions are that much better when we have questions and answers which are specific to your companies. You'll get a lot more out of this. So please feel free. You can vote. You can ask questions anonymously. Just ask whatever you can so we can deal with it by our panel. You have the advantage of having a true panel of experts here. So make use of it. But on that score, importantly, pro bono service by COBRA. If you want us to consult with your team via Zoom, a private meeting, we can do that. I've dealt with the suspension of contracts. I've dealt with the moratorium. We've dealt with the objections to the company resolutions. I'm going to deal with another important takeaway, and that relates to what happens if you want to put money into the business now to, let's say, pay staff salaries because you're very loyal to your staff, but the business doesn't have any money. Should one lend money to the business in those circumstances? And this is really a question for Ian. Ian, take us through what post-commencement finance is and why it's so relevant in relation to making payments as I described.
Thank you, Maurice. Yes, post-commencement finance is a critical part of most business rescues nowadays. Now, every company requires finance to keep running when the company is in business rescue. So we call that post-commencement finance. Now, in the developed world, countries like America, the market for opportunistic post-commencement finance is quite advanced. In other words, there are funds and there's money readily available to invest in distressed companies. Over here, it is much less evolved. It's a very immature industry. There are a few players doing it at the moment who we know quite well. But inevitably, the company that invests or the funder that invests money into the company post-business rescue is somebody who's already got a vested interest in that company. In other words, the shareholders or the banks that already have money in that company. So a fairly critical part of every business rescue is to approach those funders for post-commencement finance. As Maurice said, it's very important, and that when you're putting money into a company, that if possible, if the company does go into, if the intention is to put the company into business rescue, then it's important to put that money in after it's gone into business rescue as opposed to before. Because if you put the money in before, it's the ranking of the repayment of your loan is way down there, sort of, with concurrent creditors. If you put the money in after it's gone into business rescue, you enjoy a much higher ranking while the company is in business rescue. And if your post-commencement finance is secured by an asset, then should the company go into liquidation, then you will rank right at the top as far as the repayment of those amounts go. So yes, if you're going to put money into the company, having the company in business rescue is definitely advantageous to you as a creditor, because your money, or the repayment of your money, ranks way above all the other creditors.
Yeah, I think that's important. Just to highlight that outside of the present climate, we've dealt with business rescues where the rescue has been put it into business rescue, get the PCF in, the post-commencement finance, and then pull it out of business rescue, because the plan, all it required was the PCF. The lender was only prepared to provide the finance on the basis that the additional security be provided, the order of preference. And so you do it in that way. So it's an important takeaway. If you're going to be lending money to the business, then please seriously consider putting it into business rescue, even if it's an in and out. But the engaged guys and the IQ guys would consult. I see I actually erroneously said IQ is not on the panel, but we've got several IQ guys. So my apologies to that. We've got Francois, Artisha, and Derek. I didn't see them because I didn't have the panel view on. So we have a question here. I'll direct this to Peter. Will a request for a rental holiday be seen as an act of insolvency? Are there any benefits for landlords to apply for tenants to be placed in BR? Let me deal with the first aspect before we get to you, Peter. Will a request for a rental holiday be seen as an act of insolvency? So it's a good question. Ordinarily, the moment you ask for a compromise from your creditors, the request for a compromise is an act of insolvency and in fact can be used. So much so that even without prejudice discussions, it is an act of insolvency. In fact, it's not covered by privilege. So it's something to be mindful of. But now the company is in business rescue. Okay, so the company is in business rescue. There's no problem making those submissions because it's in business rescue and it's being treated as a factually or commercially insolvent company. If it's outside of business rescue and the offer is made, you still have the option to place it into business rescue if they take the view that it's an act of insolvency. The problem here, though, is if it's not in business rescue and you make the offer in compromise and you don't hear anything else. And the next thing, because of that act of insolvency, the accreditor launches an application for your liquidation. At that point, because there's an application for liquidation pending, you cannot resolve to put the company into business rescue. You have to then counter apply in the court proceedings to have the court then place the company into business rescue, which obviously is undesirable because now you're dealing with a high court, an opposed high court application, which can cost hundreds of thousands. Another thing I should mention is I think the courts are going to be far more forgiving on the labor front and the insolvency front when it comes to considering business rescue versus liquidation. So just to the second part of the question, are there any benefits for landlords to apply for tenants to be placed in business rescue? Peter, your mic's off.
Reece, look, obviously the landlord has the right to do that because he's a creditor. He has to go to court to do that. He could try and negotiate with the directors and tell them the advantages. If he places the company into rescue, obviously he is going to have to deal with a new party, being the business rescue practitioner, and then it's going to be subject to whatever's in the business rescue plan. Now, the practitioner, if, for example, decided that the lease agreement was not commercial and it was Ian, help me with the word. What do you call the contract when it's not, it's not in normal commercial terms? There's a word for that. It slips my mind at the moment.
Oh, sorry.
If he believes that, the practitioner again can go to court to have the lease agreement set aside. This is a common issue where you've got shareholders decide to buy the building that they're operating from. You've got an operating company. The shareholders are not of the property owning company, have a stake in the operating company, but don't have a majority. Very common where a family business has been sold to new operators and the parent or the property owning company decides to charge a fairly increased rent merely to get the income out of the underlying operations. In that case, the practitioner, if the operating company is in rescue, can go to the court, apply to the court to have the lease set aside on non-commercial terms. But by and large, it is sensible if the landlord believes that there's something there worth saving, exactly as Ian and I would do in any rescue. If the landlord believes this is really quite a good business and in the current market he's unlikely to get another tenant because there are not people queuing up to rent premises at the moment, then he would be best advised to do that. Failing that, applying for liquidation, remember what Marie said, it immediately goes, first of all, there's the cost of the liquidation, the 10, 6, 3, and 0% of liquidators' fees. So that can be quite expensive. Secondly, any contents in the shop or the premises doesn't necessarily, the landlord would have a hypothec over them, but is not guaranteed he's going to get all the proceeds of the sale. And then most importantly, it's now a forced sale. So even if it goes into rescue, and which the practitioner is allowed to do is to wind the business down in rescue in a controlled manner rather than a forced manner, must surely give a better return to creditors at large rather than under the auctioneer's hammer. So generally, yes, it would make sense, but obviously there are going to be cases where the landlord can see a valuable asset there or believe that there is money that would be forthcoming out of a liquidation, and then is best pushed to go for liquidation. The other side with liquidation, of course, is that you do, if you're the one that's got the application in, you do get ahead of the curve, and you're now preferred over any other creditor. Remember, in a rescue, all creditors are treated equally. Secured creditors obviously no different other than that they have security, and the practitioner cannot prefer one creditor over another. So a landlord is sitting in a rescue, his tenant might be there for the next 2 years whilst this rescue is ongoing. But as Maurice rightly said, one's got to be very careful that the practitioner has then suspended the lease agreement and then entered into negotiations with the landlord. Because if the premises are critical to the business, normally they are, then you would want to remain, the company would want to remain in situ. So yeah, it's not an easy question to answer blindly without knowing the facts, but the individual facts will drive which is the better route to take.
It would also sort of point out it would be odd for the landlord to apply for a business rescue, because it's primarily the landlord that's the financial burden in businesses. So why would a landlord who's mindful of the fact that they'd have to agree to a plan rather not approach the tenant and say, listen, I'm prepared to make some concessions. You don't have to go into business rescue, but let's work something out. In the restaurant industry, there are obviously going to be a hell of a lot of business rescues. But historically, we've done a lot of business rescues of restaurants. And often when it comes to the restaurant, if the landlord plays ball, then you can save the business. And I mean, the most recent example involved a restaurant in Camps Bay. We put the business into business rescue. The business rescue practitioner, first thing he did was dealt with the employees, gave the employees comfort, which we'll deal with, those meetings, but then approached the landlord. Landlords realized that it was bona fide, that it wasn't nonsense, that market conditions had changed, and the landlord decided to give a temporary reprieve to the tenant to allow the business to continue. So what the landlord did is decide on the lesser of two evils. Liquidation, where the landlord wouldn't get any further money and would have to re-tenant and pay commissions in relation to that, or give a remission of rental, which conceivably could actually be the amount of the commission. So rather, as opposed to terminating and finding another tenant, take the agent's commission and give a remission equivalent to that. So you're neutral, or go further, which often you'd have to do.
Maurice, can I jump in there very quickly?
Yeah.
In our experience, it is very unusual for a landlord to apply for a tenant to be placed in business rescue, but for the reasons that most of the time they are applying for eviction, or they're trying to evict a tenant or liquidate them, or as the case may be, once they run out of patience. But for the reasons that Peter has described, it is a very viable alternative for a landlord to do that. My only advice to landlords, and to any other creditor for that matter, who is considering going to court to have a tenant or a debtor to be placed in business rescue, is just to consult extensively with the business rescue practitioner in advance, and to know who the business rescue practitioner is going to be before you take that step. Part of the court application anyway will be a nomination of a business rescue practitioner to run with that business rescue, and make sure that person is very well known to you before you embark on that course of action.
I just want to deal with another topic, and I'll deal with it, and that is, I'll put it up on the screen. Paul Michael sent me a private message pointing out that this is important to deal with. It's one of the takeaways that you need to be mindful of. So if the board of a company, in terms of section 1297, if a board of a company has reasonable grounds to believe that the company is financially distressed, but the board has not adopted a resolution contemplated in the section, the board must deliver a written notice to each affected person setting out the criteria referred to, in 1281F that are applicable to the company and its reasons for not adopting the resolution contemplated in the section. So for a moment, virus. If a company found itself in financial distress, it would be obliged in terms of the section to put business rescue to the vote. So the moment the board holds the view that it's a very low threshold, the moment the board holds the view that there's a likelihood that the company will not be able to pay its debts within the ensuing 6 months, that's all that's required for the board to adopt a view and then put it to the vote. If the board elects not to, it has to give the notice as contemplated in this to creditors and to the various affected parties, setting out why. Now, prior to the virus, it was very, very difficult to set out why, because you'd have to come up with a logical reason. Whereas now what's happened is we have the virus, and there's a very good reason that the board can give as to why it has not adopted a resolution in terms of this, and that is that you've come into the COBRA environment. So all one would have to say, and in fact, we have a notice to creditors drafted for you to send to your creditors, basically saying, we've elected to go into the COBRA environment. We've put it to the vote. We're not voting in favor of business rescue because COBRA makes the most sense. COBRA is pro bono for the purpose of mediating a solution, and the business rescue process can be avoided if we get these mediators in there to try and solve or to negotiate between the debtor and creditors. So be mindful of that, if you want to avoid a vote, you've got to come up with a reason now, because most companies are financially distressed, and you've got a good reason to comply with your obligations in terms of this section, and that is we're in the COBRA environment. So you'll have complied if you do that.
Maurice, could I just chip in a few practical warning notes? As I said earlier, SIPC have indicated that they will take no action under Section 22, reckless trading, if the company is in distress because of the virus. So
and I think, sorry, I'm going to interject there because there's a question I was actually going to direct to you by one of the, and that is, what are the risks for directors during COVID because they are trading from an insolvent position? So you're actually answering the question, but I'll point out that there is a question,
and I are on the same page.
Okay.
But prior to going in, just be very cautious of any, and it's not only board minutes, if the emails and exchange of letters, etc., that state, we can't pay, that is a declaration of insolvency. So be very careful of that. But obviously within, as Maurice rightly says, and I've just done one, I'm advising a listed company at the moment, and as often is the case, the non-executive directors were quite keen to put the company into rescue. The executive felt that they could trade out of this. And we were in deep negotiations with some shareholders, as well as the bank, to continue funding. It was and is continuing. And I was asked to give the board advice, which I did. They were on the verge of taking a resolution to go into business rescue. And I told them that's silly. You don't need to, because there are actions being taken by the board to assist this company through this difficult period. This was before COVID-19. Bizarrely, just in square brackets, this company provides essential services and their sales are booming at the moment because they are supplying to government. But the question on directors post-rescue, the directors still carry full fiduciary responsibilities. So any responsibility that rests on the director's shoulders, a reminder, is all independently, not jointly. So each director has to act independently in coming to his or her own decisions, remain. Nothing changes. Importantly also, the business rescue practitioner carries the same full fiduciary duties. So during that period, as Maurice has said, there's the moratorium. So nobody can take legal action against the company, but that doesn't prevent anybody taking legal action against the directors or indeed the practitioner if they have contravened and acted in bad faith vis-a-vis their fiduciary duties. Now, that's a very unusual case, but obviously, and I have unfortunately dealt with a couple of rescues where there's been fraud. There is an opportunity to take action against a director by anybody who feels that they've been wronged and has lost value. So that could be anybody, a shareholder, a regulator, the police, a creditor. So directors are still exposed there. So I often ask the question, in fact, I was asked the question just before this meeting, should the directors continue with their liability insurance for directors and officers? The answer is yes. If the practitioners believe that they're at risk as well, they're not obligated. They may take out professional indemnity insurance as well. So any insurance to cover directors, and this is particularly pertinent in the listed environment or an environment where you've got non-executive directors. Because nowadays with the fairly onerous terms of the New Companies Act on directors and senior managers, people are quite reluctant to take on a position without proper insurance in place. So the thing is there to make sure that directors are still behaving in the best interests of the company. Another thing, not particularly in the question, but what happens if the directors aren't? The practitioner is in supervisory control of the board. He can't fire a director. He has to go to court to have a director removed. But he or she can decide which directors they're going to want to use, because you can call upon any management or directors to assist with the rescue. So I've had a situation where the finance director helped me extensively in a rescue, but the other three directors are basically sidelined. I kept them informed, only because they were also creditors. Two of them had been involved in nefarious acts. They were being investigated by the regulators. So you can exclude the directors. It's, however, I have to say from both Ian and my point of view, is not the preferred route. We try, one of the issues that we work with is fundamental trust. We have to trust the directors, they have to trust us. Same goes with the creditors. Not that we have to trust them, they do have to trust us at doing the proper job. But we try and work with in a collaborative manner rather than against. Because as soon as you start working against, your eye gets taken off the end goal, and then you're wasting time, potentially, negotiating through lawyers who are trying to find a settlement for you. And that really is a waste of time and effort and, dare I say, money to try and resolve that, whilst really what you're trying to do is save the business to the benefit of the creditors.
Yeah, thanks Peter.
Can I just add something to what Peter was saying earlier, and following on Madeleine's question? I want to point out that according to Chapter 6 definition of financial distress also covers factual insolvency, in other words, trading from an insolvent position, as well as commercial insolvency. In other words, the belief that you, in the next 6 months, may be unlikely to pay your creditors in the normal course of business.
The interesting point there, Ian, is that the Chapter 4 of the Companies Act covers the financial stability of a company when you're doing fair and reasonable reports. And Section 4 says that the company must be able to pay its debts as they fall due in 12 months. So what Chapter 6 has done is brought that forward by 6 months. So you only have to cover that for 6 months to say you can't pay in order to decide that you are financially distressed.
Thanks,
I
guys.
also want to go back to the question about committing acts of insolvency. So it's important to remember that many commercial contracts, in fact, I'd go so far as to say most large commercial contracts often deal with scenarios like we're in right now. So they'll have clauses which say if there is an act of God, which will generally include pandemics, there will be a payment holiday which is built into the contract. So there's a difference between saying, I have an obligation to pay you, but please can we negotiate that I'll pay you at a later stage or I'll pay you at a lower rate, between saying, in fact, in terms of my contract, I no longer have an obligation to pay you because the contract specifically deals with these scenarios. Of course, if there's no obligation to pay, if you were to write to your landlord and say, in terms of the contract, I no longer have to pay you during the period of the lockdown, then of course that won't be an act of insolvency.
That's brilliant. It can't be an act of insolvency if you don't have an obligation. You're saying, look, it's a vis major. This is the situation. Look, all contracts, a lot of people are trying to rely on a vis major, and their reliance is misplaced. Vis major is very, very specific when it comes to the ability to perform. If you can't pay your rent for your house because of the pandemic and you're losing your job, you still have the use and enjoyment of the house, you remain liable. There's no vis maior that applies. I just want to go back a step, and that is, we have a question here. Will you be sharing the draft notice to creditors? That's the 1279 notice. What is the scope for M&A activity, e.g. the recent takeover of the UFO by Lewis? So I'll get Peter to deal, or Ian to deal with the second half, but will you be sharing the draft notice to creditors? Let me actually just pull it up on the screen so you guys can see what the idea is. So you'll see here, this is a notice to creditor. We prepare it with your name in, so the notice is coming from COBRA, but we give it to you signed by us, and it says, whoever's joined the COBRA ecosystem, the COBRA ecosystem is pro bono service to businesses that urgently need assistance. It's a partnership. Due to the company's financial distress caused by COVID, the directors are obliged to consider putting the company into business rescue in terms of Section 129 of the Companies Act, which we have at this stage decided not to do. So now there's compliance of your legal obligation as a director due to the fact that they've joined the COBRA ecosystem. As the creditor of, please join the COBRA ecosystem. We will assist in mediating a financial arrangement between you and whoever within the ecosystem so as to ensure the continued survival of whoever. The idea is that we attempt to strike a balance between the creditor and debtor relationship so that everyone keeps their heads above water, regard being had to each business's cash flow requirements. We can immediately assist you. So the way it works is you give this notice, and the idea is that your creditor, who in itself will have creditors to contend with, comes in and then invites those creditors. So you have this cascading all the way from the spaza shop at the bottom, who relies on a supplier who in turn relies on another supplier, all the way up to the banks. And what COBRA has done is COBRA is engaging from the bank level so that the downward pressure can be alleviated. Another aspect which it's possibly best that I deal with, and that is in employees and the rights of employees during a business rescue. They retain all the rights that they enjoy under the Companies Act. Which includes the right to be treated fairly when it comes to retrenchments, their obligations in terms of Section 189 of the Labor Relations Act, which remain in force, and that is the duty to consult on the reasons for the proposed dismissals, the alternatives considered to the proposed dismissals. Now, Labour lawyers have adopted a view that the consultative process, whilst generally to render it meaningful, must take some time. It's a joint consensus-seeking exercise between the company and its employees. But in the current circumstances, how much time would one spend on, for instance, consulting on the reasons for the proposed dismissals? That everybody knows, and presumably there'll be very little discussion on that. So the period has in our view, being curtailed, that it's justifiable to not consult in certain aspects as one ordinarily would. But then there's also the dilemma of having to pay severance pay in circumstances where you can't afford it. And that's something that the business rescue practitioner comes in and tries to strike a balance on. We, as COBRA, importantly, and this really, really works, is we are prepared to set up Zoom sessions with the employees to try and negotiate and have them understand from an independent, impartial party what they ought to be doing, because a salary sacrifice, as an example, may be a better alternative than a retrenchment, because a retrenchment may give rise to liquidation of the business. We've also got, whilst I'm on that liquidation, there was a question about the costs of a liquidation, and that's important because it's another pro bono aspect of COBRA. If you enter the COBRA ecosystem from the beginning, okay, so you give COBRA a chance to work, and COBRA fails and does not come right, and the business rescue fails, business owners are burdened normally with a high court application that's required, which costs between 30 to 50,000 rands. That high court application is a service, a pro bono service being offered by COBRA. So if things do not work, we will be burdened with the High Court application on your behalf. You will not be burdened with those costs. And just imagine your business has failed, you've tried everything, and now you've got to pay between 30 and 50,000 rand. We've taken care of that. So if we move to the second part of the question, what is the scope of M&A activity, e.g. the recent takeover of UFO by Lewis? Peter?
Absolutely nothing. You can, if it's a listed company, you still have to comply with the listing rules of the JSE, but you can approach the shareholders for funding, assuming the share hasn't been suspended. Often when a company goes into business rescue, you have to apply as a listed company to the JSE to suspend your share. And interestingly, the JSE does not have to agree to suspend your share. So you do have listed companies that are in rescue that are still trading and not suspended. If that is the case, there's nothing to prevent any corporate finance activity to do a clawback. Clawback's a good way to do it. You're getting money in by way of loans rather than shares. And if you do a rights issue at a later stage, at which time it's going to be a lot easier to find somebody to underwrite it, because that is the fundamental problem. It's the same as PCF. A shareholder coming in to underwrite a rights issue is not going to be fully attracted by something that's in rescue. The other thing in corporate activity on the M&A side, the practitioner, and as I said earlier, is in complete control, supervisory control of the board, but completely control of the business. That includes its assets, its staff, its whatever, its intellectual property, etc., etc. So the practitioner can put in his plan that the part of the rescue is going to be selling off trading divisions, to sell off subsidiaries, which may not themselves be in rescue. So you can, it's the fundamental rules of business rescue. It's business as usual, other than you have the moratorium. So anything that a company could do prior to rescue can continue doing in the space of M&A activity.
But long story short, I think, as Peter said, every business or a lot of business rescues envisage sales of divisions or subsidiaries. So as far as M&A activity goes, there'll be lots on the selling side, but because of the financial distress of the company, it's very unlikely that the company will be out looking to purchase assets in terms of M&A activity.
And that's a good point. And I'm dealing with one that has taken me 4 years, because it's a huge property development. And how I ended up settling the creditors is I sold the largest asset in the company, a property development that was only just beginning its development. I sold it together with all the creditors. And in that sale, included financial instruments for the creditors, whereby they were secured over 3 years by way of a debenture. So the property and I also ensured that there was capital from the acquirer to make sure that this development continued. So the acquirer put funds into my lawyer's trust account. I approve all payments, making sure that they are bona fide for the development. And it went into rescue in October 2015. I took it out of rescue in July. And 2 months ago, we started selling stands. Not a great time to be selling commercial and residential property at the moment, but we are selling, and the creditors, who were all investors that had been defrauded by being told what they could invest in, Sharia-based investments, have all received 3-year debentures with a reasonable interest rate to be paid out of the proceeds of the development. And if they don't get paid, they now have full mortgage security over a portion of the property. So and that's the crux of it. One's got to be quite creative. I'm not saying I'm creative, but you've got to apply your mind and take advice on how best to find a way when everything else looks pretty dismal, when you've got an undeveloped property in a fairly godforsaken part of the country, I have to say, but valuable property because it's in a big mining area, and try and find a way to panel beat that to make it work for the development. I was advised that had I put this into liquidation and I got a formal liquidation valuation, the investors would have got between 6 and 10 cents in the rand. And over 3 years, they're going to get 100 cents in the rand plus 7% return.
I just want to mention on that score that IQ's involvement is very, very much geared towards the M&A space, in the sense that they deal with big businesses and they consult. In fact, I think it's part of their logo on contracts, and they look at this. So it's part and parcel of the solution. We have IQ when it comes to the big business to actually look at the high-level M&A stuff that may in fact assist. The benefit there is they are very, very well connected with the necessary parties to actually assist in that regard. So M&A is very, very much an option, and we certainly have the right team. Just put it out there, there are 1,000 consultants in COBRA to assist. If one takes all the consultants who are available, who have been made available to COBRA. There's another question,
and not here to necessarily polish IQ's marble, but the one huge benefit, because Ian's alluded to it, it's great to sell something, you've got to find somebody to buy it. And one of the attractions of IQ is they're well connected into the financing market. So your investment bankers, your commercial banks, obviously, as well as the private equity funds. And that is the source where most M&A activity is going to take place at the time. I'm aware that somebody like Brian Joffe, prior to this disaster, was doing a lot of acquisitions out of rescue in fairly rapid time as well, because he could see the benefit of acquiring the IP, even if the underlying business looked so it was loss-making.
In fact, we've been approached by bargain hunters. So COBRA has been approached by people who are interested in acquiring the businesses because they perceive, well, there will be bargains at the moment, and they're hunting for them. So we're actually being approached with potential opportunities.
Just very quickly on that point, Maurice, just the other warning is when you're approached by the bargain hunters, it sounds crass to say, but see the color of their money first, because you can get distracted with a lot of potential that sounds like it's great, but when it comes to putting the money on the table, it doesn't exist.
Sure. Another. I mean, these questions are excellent. Is there any way to force the counterparty to start the COBRA process, e.g., where you declare a dispute and appoint an arbitrator? So let me say this to Madeleine. First of all, I hadn't thought about that, and you may very well be onto something. Because what if in an agreement there is a mediation clause as a precursor to arbitration? Now, if there is such a clause, well, rely on that and point the counterparty to the agreement towards COBRA. So it may very well be an angle that I hadn't thought of. And rest assured, we're going to start looking at our contracts to see whether there are those provisions that we can exploit, because that's excellent. So, yeah, well done for that. Thank you.
I think especially with the new section of court annex mediations, we're obliged to look at that before we launch applications and actions. So there's even more scope. Yeah, so there's even more scope for that to look at it before we even maybe bring an application for business rescue in any event.
Yeah, I think just on that score, just so the audience understands, I'm a qualified mediator. I believe in mediation. I believe that one ought to try everything to avoid litigation, and I've seen the success of mediation. And if you have skilled mediators, you are going to be, chances are you'll be able to get to a solution that both parties are happy with, something that you never get out of the court process. What mediation is about, so the three words, it's about assessing needs, interests, concerns. So you go to the debtor, you assess that, you go to the creditor, you look at needs, interests, and concerns, and you get those up as a mediator. And the moment you marry them up and you find a middle ground, you have a successful mediation. I think it was touched on, but there's another question by Madeleine that was quite important in that, and I know you answered it, Peter, but I just want to emphasize, and that is directors normally are liable if they traded recklessly, and in these circumstances, this is by definition reckless. Peter mentioned it, but I just want to mention it again. There's now a moratorium that suspended the section as a practice note by CIPC in relation to reckless trading, and they're saying, for now, we're not going to be relying on this section. Do not worry about it. So quite a lot has changed in relation to the approach by the authorities and by the courts. Is there anything anything further that the panelists want to ask? Was there anything that I've missed?
Maurice, there's another question by Madeleine here, and you covered the costs earlier of putting a company into liquidation. But her question here is, what are the steps and costs for the application by an affected person to place the client into business rescue, and are the courts open? I would think that the costs of placing a company into business rescue would normally be slightly more than placing it into liquidation from business rescue. Am I right?
Because let me say this to you, okay? If you're applying to court to have a business rescue, an order to place a company into business rescue, chances are it's hostile, because you'll have requested the board, you'll have said, why is business rescue not appropriate? They would have responded and they would have given you a reason, and you wouldn't have accepted it. So you go to court, and that process would be adversarial, and you'd be burdened with a high court application, which goes to the Constitutional Court for whatever reason, millions and millions and millions. So probably in a situation like that, what you want to do is you actually want to go for a liquidation, and then get the respondent to counter apply, saying no, liquidation is not appropriate, let's do business rescue, if you were to do that. But that's something you've got to avoid at all costs, without a doubt.
And I think that's why, let me just touch on this, the fact that 99% of business rescues are Section 129 or voluntary business rescues. In other words, where the board actually places the company into business rescue. The other 1% are companies that are placed into business rescue as a result of a court application. And yes, as Marie said, most of the time that is hostile. It often doesn't make for cooperation between affected persons and the business rescue practitioner. You would have recently seen the case of where SA Express was placed into business rescue via a court order, as opposed to SAA, which went into business rescue voluntarily by a board resolution. So in the SA Express matter, government basically refused to, or let me not say refused, but there was very little cooperation between the business and rescue practitioner and the Department of Public Enterprises. And that can largely be attributed most likely to the fact that the company was placed into business rescue via a court order instead of the creditors getting the buy-in of the board to put it into business rescue voluntarily.
You know what we haven't dealt with, what I'd like to deal with in the last 5 minutes, and thanks for that, Ian, is the business rescue. So whilst you're speaking, just deal with the business.
Sorry, Maurice, I've lost you.
Ian, I think Maurice wanted you to cover the business rescue, the costs, the fees for business rescue practitioners.
Yes, certainly. Okay, so the cost of business rescue are dictated by Chapter 6 of the Act. It specifies a fee for a small company, a medium-sized company, and a large company, and the definitions are included in there. Typically ranges from 1,250 Rand an hour for a small company to approximately 2,500 Rand for a large company.
Did I cut off there? Sorry, was I?
No problem. We assumed that the question was about.
No, I see you're dealing with costs. The question was directed at the business rescue plan, its approval, and the votes.
Okay, let me deal with that, Ross. Let me just finish about the costs, because it is quite pertinent. Yeah, so the Act basically specifies, with the Act, bearing in mind it was written in 2008, specifies a small company is approximately 1,250 Rand an hour that the business rescue practitioner can charge, up to a large company which is approximately 2,500 Rand an hour. It is considered that those costs are outdated, and most business rescue practitioners require sort of a higher fee and a contingency fee at the end of the day. Those fees can be put forward by the business rescue practitioner as part of the business rescue plan and voted on by the creditors in the meeting to approve the business rescue plan. Should be noted, while we're on the subject of fees, in terms of the COBRA initiative, none of the parties are going to, the whole pro bono aspect of it is that none of the parties will allow fees to stand in between to stand in the way of a successful business rescue. In other words, if the difference between a successful business rescue and a liquidation, in other words, a failed business rescue, is the fees, then those fees will be incurred on a pro bono basis. In other words, they won't be charged for.
Yeah, I think it's important there. It's just to mention that that's the means test when it comes to all pro bono. Pro bono is designed to help.
I think we've lost you again, Maurice. Should we move on to the business rescue plan then?
Shall I just quickly dive in there?
Yes.
Because I think we are running out of time. Business rescue plan, it's got to be presented to the creditors for voting within 25 days of the business rescue's practitioner's appointment. Impractical, normally takes a lot longer than that. He puts a plan together which hopefully has the support of most creditors, a lot of behind the scenes negotiations with the people that will vote on the plan. The plan is dictated in terms of the chapter 6 as to what's got to be in it, the history, what went wrong, what the practitioner's done, and then most importantly, the financial effects of the rescue and how you plan to pull it through. The critical document, there's the cash flows, how much cash is going to come out of it. If there's a compromise, you put the compromise in the plan, i.e. you're asking the creditors to take a haircut. The plan is then presented to all the creditors. You need 75% of those voting in person or by proxy to say yes to the plan. The plan is then approved and adopted. Of that 75%, 2/3 has got to be, of those votes have to be independent, i.e. not connected to the company, not shareholder loans, not director loans, not intercompany loans. So anything that's classed as non-independent has a diluted vote. If it's voted through, it is then sacrosanct. The practitioner then performs under that plan to implement it. All he's allowed to do now is implement. He can, excuse me, just clearing a frog. He can amend the plan if it's nothing major, because it's, as I said, you've got to have the flexibility, and that's quite critical here, to not have to go back to the creditors every 5 minutes for another vote. He implements the plan, and once the plan is substantially, an important word, substantially completed, he can take it out of rescue. Substantially means that you've almost there, but you've put controls in place to make sure that the rest of the plan is properly implemented and creditors are paid. Normally creditors get paid dividends over a period of time, unless you've had a big asset sale and managed to pay them all immediately. And once the plan is substantially implemented, the practitioner then applies to Sub-C to have it taken out of rescue. If you can't get the 75% vote, there is a fairly formal process to go through, but essentially if you can't get agreement between the creditors, underlying shareholders are not voting here on the plan at this stage, then your plan fails and ultimately would go into liquidation. There is a process to go through to try and make sure that that doesn't happen. But if you fail that, the practitioner is then obligated to put the company into liquidation. If the shareholders' rights are not affected, they have absolutely no vote on that plan. It's only if you're affecting their rights, changing the terms and conditions of the shareholders' rights, including preference shareholders, then they would have a vote on the plan, but otherwise not.
Let me just jump in there, Peter. If a business rescue vote has failed, in other words, if the business rescue plan has not been approved in the Section 152 meeting, then it must be noted that there still is a course of action that affected persons can follow. In other words, that shareholders or creditors or employees can follow, and they may apply to court to have the vote of the creditors set aside as inappropriate. We have seen that in a few instances, and there is case law to that effect.
Yeah, that's particularly when there's a situation where the creditor is not being bona fide and the ulterior motives. I'm going to conclude. There is one final question which deals with, I'll read it to you. What are the views on the pressure on the commercial property sector spilling over and causing systemic risk? Well, my view is that if it wasn't for business rescue, the risk could be manifest, it would be massive. There still remains a risk, but the pressure that you refer to in the question is ameliorated by the business rescue process and the fact that we have the provisions in the Companies Act. If we didn't have those provisions, I have no doubt the government would have passed urgent regulations in terms of the Disaster Management Act, so deal with it. So there's probably the systemic risk is as high as it's probably ever been in South Africa. There would be a complete financial collapse, in my view. That initiatives such as COBRA are alleviating the pressure, and hopefully we won't have an entire. Thanks, everybody. Thanks for brilliant questions. I must say, these certainly got us going and got us thinking. Please contact me directly on crespi@schindlers.co.za or write to info@cobra.org.za if you want to set up a private meeting, if you want to have debates around systemic risk. Love to have those debates. Let's actually talk through it, because it's actually quite relevant. It's relevant in relation to business. What are the risks? What should one do? Should one dispose of assets at a discount? That it's an important question that I think the business rescue practitioners, engaged IQ, everybody must take into account when it comes to the M&As and the pricing, etc. So thank you very much. Thanks, guys. I hope to get direct communications from you. Otherwise, join us on Monday. Thanks so much.
Thank you.